Okay, thank you very much, Lee. Obviously, the topic for today's webinar is one that's been popular and relevant, I think, ever since NACADA began. And since I've been there all that time, I can verify that, whether it be at conference presentations, in the literature, or whatever. Also verified by the fact that we have over 100 institutions signed on to this webinar today. So let me introduce our speaker now. Audrey Wolfson Latourette is a cum laude graduate of Temple University School of Law, where she was also associate editor of the Temple Law Quarterly. A former associate at a large Philadelphia law firm, she was recently named Distinguished Professor of Law at Richard Stockton College of New Jersey, where she and I have been colleagues for the past 35 years. Has given numerous presentations at regional, national, and international conferences and has been invited to speak at various colleges and universities throughout the country. Her recent publications include, needless to say, Legal Implications of Academic Advising in the NACADA Monograph on Advising Administration. Her range of expertise is reflected in some of her other publications, including Papish versus the Board of Curators of the University of Missouri, published in the Encyclopedia of the Supreme Court of the United States. Copyright Implications for Online Distance Education. American Federalism and Abortion. Sex Discrimination in the Legal Profession, Historical and Contemporary Perspectives. And Plagiarism, Legal and Ethical Implications for the University. That was published in the Notre Dame School of Law and the National Association of College and University Attorneys as the lead article in the Journal of College and University Law in 2010. She's currently writing another chapter on legal implications for transfer students in the NACADA second monograph on that topic, which is due out in October at the Nashville conference. Audrey?
Of us, whether we be faculty, advisors / preceptors at my own college, Richard Stockton, or whether you are a component of a staff of faculty advising in whatever arena it exists in your particular college or university. Since the advent of NACADA in 1977, the issue of faculty advising has really risen in profile and importance, and markedly in the higher education context, particularly with respect to retention, graduation, and transfer rates. And for all of those who are in academic advising, the word transfer will resonate because you're all aware of the legal implications related to that issue. I mean, in what is a better exhibit of the impact of state and federal intervention into what had originally been our autonomy, our right to examine credits from another institution, determine what would be accepted, what must be enhanced, what must be repeated, and so forth. But I think many of you will be familiar with the mandates by state legislatures, by the Federal Department of Education to enter this arena and to dictate by virtue of law what that decision making may have to be. In New Jersey, for example, we have a statute which absolutely mandates that if one graduates with an AA or an AS degree from a community college, that student will in fact be a junior at the four-year college. So there is no question that at whatever level of education, including public education, elementary and high school, wherein faculty have to be aware now of sexual harassment on a school bus, of First Amendment rights with regard to clothing and texting, whether faculty, students and teachers can engage in social media. Some states have actually barred teachers from entering a Facebook relationship with a student. And so we're all aware that all of academia works within an increasingly complex legal arena. And it is absolutely an issue of great importance to all of us. Nonetheless, whatever form of advising we engage in, whether it's the traditional hard copy, the old school form, the online banner system, the email engagement, the face-to-face, the use of Twitter, and the like, our goals essentially remain the same, and that is that we give correct advice to students, which will enable them to graduate in a timely fashion, which will enable them to satisfy the requisites of their particular major, satisfy the requisites of athletic and academic scholarships, prepare them for the graduate school, and indeed graduate them in hopes that they are fully prepared for the working world. And so this concern is accompanied by another concern, and that is, what if we err when we are rendering those decisions, when we are proffering that advice to students? That concern has been addressed by several who make commentaries with regard to legal liability of faculty and faculty advisors and staff. And if one reads that commentary, you might detect a landscape that looks somewhat ominous. So some predict a landscape strewn with litigation, wherein we are the defendants in these cases. Others speak of an evolving legal liability on the part of advisors, and this is true to a certain extent. There is no question that the complex legal arena for us, really indeed for all of society, is increasing. But what I would urge is that my examination of the litigation that has been brought by students against advisors and colleges and universities is not only what one commentator has said. He said they're not fabulously successful. Well, I would urge that they're rarely successful. So irrespective of what basis for a lawsuit a student premises his case on, we would deem that a cause of action in the law. And those causes of action include negligence, breach of fiduciary duty, breach of contract, and estoppel. Irrespective of which cause of action is utilized, it is really infrequent that students emerge victorious from this litigation. There are three primary reasons for that, and I will address these in greater depth, but just wanted to set those forth now. One is that notwithstanding the increasing federal intrusion by the Department of Higher Education and in Washington and state and federal mandates, the judiciary continues to hold us in high esteem and issues decisions reflective of that respect and traditional stance with regard to academic decisions. So it's a form of deference that continues to be exhibited by the courts. Secondly, while not all, but many colleges and universities utilize language in their bulletins which explicitly maintains that the ultimate decision-making for a student with respect to the courses that must be taken to satisfy all of the requisites that I had mentioned earlier in the introduction lies with the student and not with the advisor and not with the institution. Thirdly, notwithstanding many commentators' lusty embrace, as it has been termed, of this cause of action known as educational malpractice, it is one that almost uniformly has been rejected by the courts. So what I find and what I hope to illustrate in this next hour is that barring instances of gross negligence on your part, not ordinary, not typical mistakes, but gross negligence, or we might even say gross indifference to the standards of academic advising, or fraudulent, which would be intentionally misleading conduct on the part of advisors, or conduct that could be deemed arbitrary and capricious, such as at one institution in Florida where 2 months prior to graduation, a student in an osteopathic medical school was not permitted to graduate. When the court reviewed that scenario, it said that the institution had acted in an arbitrary and capricious manner in denying the student a degree. So let's begin first with this notion of traditional deference to the college and university and to its staff and faculty. This really commenced in the 1980s with a landmark case called Dixon versus Alabama State Board of Education. In essence, what it mandates is that when students sue, and this is not just related to academic advising, but tuition has gone up, and it's more than you promised me when I entered this institution, or you have now required a course that was not part of my curriculum when I entered this college, or You said that you would provide tutorial services. I was a disadvantaged student in law school, and those tutorial services have not been forthcoming or are not satisfactory. In all of these lawsuits, what the courts look for is that if you are a public institution, that you provide, as mandated by the Constitution, due process to students. And that is, though, a flexible form. In other words, courts do not rigidly adhere to, if I don't see these 5 steps articulated and implemented by this institution, then we have a severe problem. Rather, they just want to see that there is an opportunity in those public institutions for a student to be heard, for a hearing to be held, perhaps an attorney as a representative, but not necessarily. In the private university context, because the Constitution is not applicable in the same fashion, there the standard is deemed what's fair, what's reasonable. And in essence, it equates to due process in a public institution, so that the courts look to see that when our decisions are made, particularly in academic decision-making, and rather than punitive decision-making, that they are rational and reasonable. I'll give you a couple of examples that have to do with a public institution. Texas A&M, in just the last 2 years, had a case wherein a professor in business indicated to his classes on his syllabus, plagiarism will be harshly penalized in my class. And if I find that you have plagiarized, I will place your names with your failing grade on my blog. The professor concluded that 6 students had in fact plagiarized, and he did just as he espoused. He placed their names with their failing grades on his blog. I can envision many of you recoiling in horror because you realize that minimally this was a violation of FERPA. We cannot discuss the adult college students' grades with their parents, let alone place it on a public blog. But in addition to that, by doing this, by telling these students that was it, they were out of the college, he had violated their rights to due process. He had not given them an opportunity for a hearing. Another case which is more related to our topic is Mahav Gonsanan v. Hall. And in that case, the student had entered, I believe she was a computer science major, but the subject matter is not the most relevant part. When she was close to graduation, she was advised that she needed to take another course. The rationale for that is that the technology had so increased, was so enhanced, that the college felt it incumbent upon them to have her fully prepared for the marketplace by having this course. She brought a lawsuit against that university, and she premised it on breach of contract, that the brochures, that all the writings, the bulletins, and so forth of the institution set forth a curriculum that existed when she entered, and she felt it was a violation of that contract to modify it. In exhibiting the court's deference to our academic decision-making, the court concluded that since the college produces graduates, sets them out in the world, and in essence conveys to the world these individuals are competent in the areas in which they have been trained and educated, that indeed, if the college felt it very imperative that the student have this course, it had the academic discretion to mandate it. Now, we know that in many of our institutions, we also have that freedom. In my institution, we tend to grandfather students in so that they are not confronted with an extra requirement. But the fact that the court supported this is reflective of its the discretion that it affords us in these cases. And lastly, one other case that best illustrates the deference is Napolitano versus Princeton University. Briefly, she was a senior student, an A student, a scholar, athlete, the type of student which engenders praise from all who know her. And in her final class, which was a Spanish class, and in which she did not excel, she had to write a paper. The professor recommended a book that she utilized and quote from in her paper, and she utilized that text. And in many cases, she did afford it sufficient attribution, but not in every instance. The professor failed her for plagiarism for the paper, for the course, forwarded this to the proper committee at Princeton. In short, that committee, comprised of faculty, students, administrators, and so forth, concluded that she had plagiarized and they would not permit her to graduate that June. They deferred her graduation one entire year, and all graduate schools to which she had applied were notified about the reason for her failure to graduate. Gabrielle Napolitano brought a lawsuit in New Jersey Superior Court, Chancery Division, and the court was quite clear in his opinion, and courts of course don't always convey in any way a personal opinion, but said, Princeton seems to have a rather ad hoc approach to plagiarism. One year, a student is permitted to rewrite a paper. Another year, a student's graduation is deferred, but only until August, so that there is no interruption of graduate studies. But in this case, Ms. Napolitano was not allowed to graduate for a year. The court said, I cannot mandate compassion, and indeed I should not substitute my opinion for that of the university, thus making it very clear that the judge vehemently disagreed with the harsh treatment that Princeton had afforded the student, but most significant for us, upheld the decision of Princeton University. So let's begin then with a discussion of the student-initiated litigation premised on errors or alleged errors, perceived errors in academic advising. The first cause of action, and by cause of action I mean when you have been injured and you're planning to sue someone, there's got to be something in the statutes, in codes, in common law that the defendant has violated. Thus, if you are like the 24-year-old man that I read about, who never graduated from college, spent a lot of his time teaching tennis, teaching skiing, and then found that he had no job that he deemed desirable, that he had not finished college, sued his parents for negligence. His standing, his injury was economic. He'd not completed school, did not have a sufficient career, and so forth. But the case was dismissed for lack of cause of action because indeed, unfortunately, we cannot be sued for negligence by our adult children. So when I speak of cause of action, the first one we're going to look at is educational malpractice. What can you liken this to? To negligence, to malpractice as you've heard it spoken in reference to accountants and lawyers and physicians and landscape architects and architects. And that is this notion that a plaintiff is injured because you have tendered advice. In tendering that advice, which is erroneous, you had a duty to that person. You departed from that duty, not intentionally, but you've departed from it. And in so doing, it's foreseeable that someone's going to be injured. And this is what the students are arguing in this particular case. And they may argue their injuries. They had to take extra courses. They lost academic eligibility for scholarship or athletic eligibility. So I think it's best explained when I give you some examples of cases that illustrate this particular cause of action. In this one, the court, there's a wonderful quote I love. The court said, education malpractice has a, quote, seductive ring to it. And it is a theory beloved of commentators, but not of the courts. The rationale for this, in educational malpractice, we as a student would be claiming, you didn't teach me properly, you didn't advise me properly, I didn't learn enough, I didn't take the proper course. Courts are very reluctant to enter this terrain, and the reasons I think are self-evident in many instances. One is, unlike an accountant tendering advice to a client, in teaching, in advising, we are engaged in a collaborative process. We are rendering advice, but we are listening to input from the students, and the students are adults in our instance and are expected to read brochures, read bulletins, and have a full understanding, especially after speaking with us, of what the requisites are for majors and so forth. And so that's the first notion, that it's collaborative. Secondly, the court has great reservations about how would they determine whether you hadn't succeeded in a course because the teaching was poor or because your contributions to the class. The same issues exist with advising. And thirdly, and most practically, the courts are very concerned that if they recognize this as a cause of action in the teaching or in the academic advising context, they would be confronted with a deluge of complaints. I will note, and I would be remiss not to note, a case that has garnered much attention. Notably, it was within the high school context. It is called Sane versus Cedar Rapids Community School District in 2001. And it has been examined by many commentators and viewed as a foreboding. In other words, as setting precedent that in this case, which established for the first time that it was the first jurisdiction to recognize this tort of negligent misrepresentation with regard to a guidance counselor at a high school. Commentators are very concerned that this will then be applied to the university setting. I don't share that same concern. I'm certainly not projecting a posture that this could never happen, but I see reasons that I would not portend doom occurring. Let me just briefly tell you about the high school case. In this case, this student had received a basketball scholarship at Northern Illinois University, a 5-year scholarship, a wonderful opportunity for him. And he had to satisfy NCAA requirements. There were certain English courses that he had to be taken. And all of the high schools in that state submitted those courses to NCAA for approval. The particular course at bay in this, or at issue in this case, had been submitted to NCAA by many other high schools and had been accepted and was deemed an appropriate English course. Unfortunately, in this case, at his high school, Cedar Rapids Community School District, the high school had failed to submit that particular course, the same exact course that had been approved on many other occasions. Because of that failure, because of the failure of the advisor in this high school to discern that, note it, he lost his scholarship and without private funding was unable to attend the university and compete in basketball. It's a very sad case, as many of these are, and you feel great sympathy for the students. But I want to make clear that why I don't think this is as discouraging for the college and university context as it might be. So in that case, just to clarify, the school itself was not, on the trial level, the court dismissed the entire case, saying there is no educational malpractice. There is no particular duty to inform with such specificity. But on the appellate level, though the dismissal with regard to the high school was upheld, it was not upheld with regard to the advisor. And the court said, however, that there has to be specific utterances made by this advisor about which that person knows the student is relying, and the advisor has to be fully cognizant of the relevance and significance of these statements. So why don't I think this is so foreboding for us in the higher education setting? One, it is taking place in a high school. And the high school has very different standards. In high school, for example, in loco parentis still reigns. The idea that you stand in the shoes of the parents. We in colleges and universities have discarded this eons ago. We are dealing with adults, and we do no longer have that responsibility that faculty and advisors have in the high school setting. Secondly, I would say that several states, such as California and South Carolina, have enacted legislation which affords immunity to their advisors. And I would not be able today convey to you a state-by-state analysis, but would suggest that it would be prudent to look to see if your state has afforded immunity, in other words, exemption from lawsuit, in your particular capacity as advisor. And thirdly, I would say that the court made it clear this is not based on your opinion or your commentating on future events, but rather the language must be very specific with full knowledge the student is relying on this, and so that limits the instances where this can apply. But to show you why I would mark a different case for colleges and universities, I'll point to a case which was decided subsequent to same and decided in a college and university setting. And that case is Hendricks versus Clemson University, 2003 case. This involves another student athlete, and he was a basketball player. I'm sorry, baseball, very important, very actually crucial to this case. And as a baseball player, he played for a Division II school and sought to transfer to Clemson in Division I because he had high hopes that Clemson was going to go to the College World Baseball Series in Omaha, a truly noteworthy event for anyone involved in collegiate baseball. Indeed, a couple of major league careers have emanated from participating in that particular venue. So he met with his advisor, the transfer was made, and his advisor unfortunately erred on 2 occasions and admitted that she did so, and attributed that failure to personal problems. One was that she did not properly advise him as to the full scope of courses he had to satisfy for his major. Secondly, and more relevant to this issue, is she did not advise him that 50% of his major credits had to be satisfied by his senior year. Without that, he lost his NCAA eligibility. And even though this faculty advisor admitted that she was in fact careless, negligent, accepted all blame for this event, the NCAA, in a posture I find it routinely adopts, one of rigidity and lack of sympathy, failed to give the student a waiver. So in this case, however, when he sued for malpractice, for negligence, he was not successful. The court held there is no specific duty. In other words, they did not liken us as faculty advisors to lawyers, to accountants who give specific business advice. They said in our case there is no specific legal duty to offer accurate advice, and that no liability would be forthcoming unless the individual had been grossly negligent. So I point to this case, which is consistent with many other cases premising itself on educational malpractice. Next, we're going to move to another cause of action called breach of a fiduciary relationship. You may have heard this one in the news. Child actors, I'm going to totally obliterate this name, but Macaulay Culkin, maybe something akin to that, sued his parents premised on breach of a fiduciary relationship. And what that meant was his funds, his earnings from his then at least successful movie career, were entrusted with his parents, who were serving as fiduciaries, much as a banker, an accountant, your lawyer, your stockbroker would. And so the decisions that they make and the expenditures that they make are for the benefit of the young child actor rather than for themselves. This particular one, as you can note on the slide, is used generally with lawyers, brokers, corporate directors, etc. And courts do not, though they have been encouraged to adopt this, to apply to the collegiate setting, have not, barring one instance, which I'll tell you, and it's very, very different, have not applied this to the advising context. And I will give you an example of that. One is Audrey versus Pace University. And in this particular case, the students had been advised by their advisor that their mathematical background would suffice for purposes of a programming course. It did not. They were bereft of the requisite skills. The lower court ruled that this theory, breach of a fiduciary relationship, could apply, but one must always follow through with these cases because the higher court, the appellate court, reversed this decision. So some commentators cited this as proof that this is a viable cause of action, but the appellate court ruled, and I'll quote from it, that to utilize breach of fiduciary relationship constituted, quote, mere reformulations of the educational malpractice claim, which the lower court had improperly entertained and in so doing acted in direct contravention of well-settled law. So the appellate court made it very clear that this theory was inapplicable to that setting. There is a case, a Schneider versus Plymouth State College, and commentators have written about this, wherein this theory, a breach of fiduciary relationship, was successfully used, but the context is so different, so alien from faculty advising, that it would not give me pause. In this particular case, a student was sexually harassed, a college student, by a professor. And in that instance, the court held, given the hostile environment that she had to confront, given the acts of sexual harassment that she had to face, given the disparity in power between the two parties, the theory of fiduciary relationship would obtain in this setting. But that is very distinctive and very different, and a marked departure from the typical advising scenario in which we are engaged. Before I move to breach of contract, I would just like to make one point. I'm illustrating these theories premised on one or two cases. I do want to clarify that each of these students employed almost every theory that I'm discussing. In short, when one brings a case, it's really incumbent upon the plaintiff to utilize every appropriate, every relevant theory, cause of action, clearly nothing that's, what we say, frivolous. But those which have applicability, it is incumbent upon the plaintiff's lawyer to utilize them, because if one, for example, premised a lawsuit on breach of contract, and the court concluded, no, there was no violation, no breach of contract, and you had not included what will soon be forthcoming, Estoppel, you would have lost the suit for your client. The court does not allow you to return, oh, by the way, I'd now like to try this cause of action and see if it proves more viable. You have ended your case, and you've really perhaps demolished any hopes of success for your client. And in fact, your client then can bring a lawsuit premised on negligence against the attorney for not raising every potential viable cause of action. So as I look at the next topic, breach of contract, I do want to emphasize that students who've utilized this as cause of action have utilized the others as well. So one case often includes all four causes of action that we're discussing. In breach of contract, I'll give you two, I think, examples which will, I think, easily clarify this issue. What breach of contract are we discussing? We're discussing every piece of material, every online format, in any venue possible that the college sets forth, authorized, of course, publications. That constitutes our contract with a student. If we amend that contract orally, generally in contract law, one would say, if you have a written contract and you're dealing with a party, and say you're purchasing their automobile, and you've rendered it in writing, and then you say, oh, by the way, would you include that CD player, and would you do this and that, and they orally agree. If they back out, the law will generally say, if it's not in the writing, it's not enforceable. In the college setting, that pretty much holds as well. But I would urge that if the writing is contradictory with writing elsewhere on the university campus, and then if oral statements are tendered by one in actual or to the student's eyes, apparent authority, yes, there have been cases where the contract has indeed been rendered modified. So let's look at the actual facts, which I think are the most illustrative of the issues. The first is Wilson versus Benedictine College, and I think this is a case to which many of you can relate. In this particular case, the student often, when I say often, I say once a semester, visited his advisor. And he went to a college, Illinois Benedictine College, which, like many of our colleges, mandates in certain majors you maintain in the core courses an average of at least, at minimally, a C. So, for example, a business student at Richard Stockton College must maintain a C or better in certain core courses. And if you don't, if it's a C minus, it must be repeated. Well, so too was the case at this particular college. So the student is meeting with his advisor once a semester. We're now in close proximity to graduation. And the student comes to the advisor and says, I just received a notice that I can't graduate because I have 2 Ds in my major. You never advised me of that. The professor responded, this was a professor advisor, I believe, I was unaware of the fact that you had 2 Ds. Well, that statement was quickly contradicted because when one brings a lawsuit, a period is entered which is called discovery. And even items which heretofore would have been deemed private and confidential, for example, you're a faculty member bringing a sex discrimination lawsuit. You've not been tenured. You feel that the real prime motivation for your failure to be tenured is because of sexist attitudes by your male peers. Ordinarily, you would never have access to their private discussions when they rendered their decision about you. But bring a lawsuit and all of that is accessible. Divorce your husband who tells you nothing, you'll find out about all his records, his corporate tax records, everything. And so too, in this case, when the student brought a lawsuit, the records were clearly in the professor's office, indicating that the student had 2 Ds. But does this indicate success for the student? No, it does not. The student pointed to, in his breach of contract litigation, pointed to brochures which said, bulletins which said, and I'll read the language. The bulletin, quote, recommends that students meet with their advisors once a semester. The court said, yes, this language is in the bulletin, but that language does not create any obligation to so meet. And in fact, the court says this is more in the nature, and I love this language, it's kind of reminiscent of those historical romance novels. The language is that this language provides an unenforceable expression of intention, hope, or desire, but it does not constitute a contract. So therefore, the student was not successful. In addition, I would add, the bulletins at this university were quite clear as to what the requisites were very adamant about nothing below a C can be obtained in one's core courses. And so the court said there was no ambiguity in the brochures as well, and the student had access to this, and as an adult should have been fully apprised of what his responsibilities were. Another case, a similar case, is Abrams versus Illinois College of Podiatric Medicine. Here the promise was a different one. The brochure said that one can meet with one's advisor and be apprised of one's academic growth or lack thereof. And if one exhibits difficulties, there can be help forthcoming. So one student went to an advisor. He was very concerned about his subpar academic performance, and he was assured, don't worry, we'll help you, etc. Well, he did not succeed academically, and he brought a lawsuit based on breach of contract. He said that statements had been proffered to him by individuals who seemed to have authority that they would help him. Again, the court looked to the language of the student handbook, which said it is desirable that the instructor should periodically inform the student of his progress. Again, you already know the answer. The court interpreted this as another wish, hope, and expectancy, but not a contractually binding promise. Next, we will move to a cause of action which is called Estoppel. Many individuals have never been familiar, and understandably so, with this term. If you examine it, you can see that it includes the word stop. And by the term estoppel, you're in essence saying, you've made a promise to me, and I'm going to stop you from denying that promise. Now, I'll give you a far more eloquent quote. This is from Lord Coke in British common law. Estoppel emanates from Britain. We discarded King George. We didn't want a monarchy. But we pretty much accepted all of British common law, comprised of British judicial decisions, standards of communities. We did not need to be told that murder was a crime. We have developed it by attributing degrees of intent to it. But so too, estoppel comes from British common law. And Lord Coke said, it is called estoppel because a man's own act or acceptance stoppeth or closeth up his mouth. So in essence, in Estoppel, what the student is claiming is, you had authority, or apparent authority in my eyes. You've tendered a promise to me. I've really conferred with you. Are you sure this is correct? And in these cases, you'll see they conferred not just with one individual, but with several. And now you're trying to deny that promise. I'll give you an example that's not in the university context, to which I think many of us can relate. The example emanates from a case wherein an adult male worked on the East Coast in a professional job. His parents lived in Kansas, were farmers. And as they aged, they were concerned about whether they'd be able to maintain the farm without help, besides the staff the minimal staff that they had. So they asked their son this: would you leave your job and your home on the East Coast? Would you come to Kansas? And in return, we will deed this fairly large farm, as I recall, to you. Now, one might say they're his parents. Shouldn't they give him the farm? Not in the United States. There is absolutely no obligation on the part of any parent to leave anything to adult, competent children. Unlike Puerto Rico, wherein one cannot totally disinherit one's adult children. I really prefer that standard. Nonetheless, this is what we live with. So when you hear individuals speaking about, I just don't understand why she's spending my inheritance, their confidence in receiving this is totally misplaced. Their inheritance is not their inheritance until that individual has died and has, in fact, left it to them, via wills and other documents and so forth. So in this particular case, they were offering something they did not have to offer. He did move. He went to Kansas, he ran the farm, and then they died. And they did not leave the farm to him. If you'd say, well, isn't that a contract? They offered, you come here, run the farm. He offered his services, and in exchange, he would get the farm. Yes, ordinarily, were he not a son, we could say that was a contract. There was an offer, someone accepted, they're both receiving something out of it, we call it consideration, but not in the case of a son. The court said he provided nothing to his adult parents that he was already not obligated to. But he was successful, relying on this theory, Estoppel. What he then argued, his second cause of action, was that those adult parents made promises to me. I reasonably relied on those promises and in fact changed my position premised on those promises. I left my home, I left my job, and I moved to Kansas. This is the argument that students make. And using Estoppel, he was successful. So I'll give you then a couple of cases that illustrate in the academic advising arena Estoppel being utilized. The first is Blank versus Board of Higher Education. Briefly, this was a student who was a student at Brooklyn College, and he was entered into a 3+1 program, 3 years of undergraduate, and then the fourth year actually was comprised of his first year of law school. And then on the completion of that first year of law school, he would receive his undergraduate degree. In establishing the parameters for this, he met with the Office of Counseling, the head of the psychology program, 2 psychology professors who supervised independent studies courses. The issue in his case is that he needed 2 more courses before he could move on to the law school, and he wanted to take those off campus. All of these persons with whom he conferred said that he could. So he did that, took those 2 courses off campus, then completed his first year of law school, received an invitation to the graduation, ordered the proper garb, apparel, his parents came, his grandmother came, and they arrived at the graduation to find this. His name was not in the bulletin. He was tendered no degree, no diploma at the graduation. And the response of the university? You did not take those 2 courses on campus, which is mandated by the college bulletin. He brought a lawsuit against them premised on estoppel. He was able to demonstrate that he had conferred with all of these individuals who have authority. The university responded, but look at our bulletins. Our bulletin makes clear that these courses must be taken on campus. And the court pointed out, but look at another bulletin that you produce, which contradicts that very statement. And the fact that the dean, I believe, said that he had to approve, contradicted the first statement in the bulletin. So this is actually a key argument in contracts. If you and I are entering a contract and I draft it, I simply hand it to you, sign here. And it turns out later there's language that's ambiguous in it. I can assure you that contract is construed on your behalf, not mine, because I'm the drafter. I had control, and I should have eliminated those areas of ambiguity. So too, Brooklyn College should have ascertained that it had contradictory statements in its bulletin, and because of that, the college was not able to enforce those contractual terms. And in fact, the court ordered that the university tender his degree, which of course happened. Another example utilizing estoppel, it involves a transfer student. And this transfer student is called Healy versus Larson. He was transferring to Schenectady County Community College. And as we all know, I mean, all students want to be apprised of the correct courses. But transfer students feel an extra pressure to do so. First of all, they've gone through the transfer articulation process, which is not seamless in every state or every college and university. It's sometimes confusing, and more of us are correcting these areas by the websites we utilize, by the articulation agreements we enter, and so forth. But they have that burden first. And then when they enroll in courses at the college, they absolutely want to make sure that they're not taking courses that are unnecessary. They want to graduate in a timely fashion. Indeed, we have a president who's encouraging, requesting strongly that we graduate more students with four-year degrees, and that we do so in a not attenuated fashion, but rather in 4 years or something close to that. So he met with the dean, the director of admissions, the acting president, the guidance counselor, and the chairman of the math department, who advised him what courses to take. He did so. It was time for graduation. He was informed he had not taken the appropriate courses. He based his lawsuit on estoppel, and needless to say, was successful. Two others where it was not, I'll give you one other example, it was not used successfully. This is a lawsuit against the University of Michigan by a law student, easily. And he claimed that he was taking a course which was deemed a 5-credit course, but that the professor had said, I'll give you, as his advisor, I'll give you 6 credits for this. He did not receive 6 credits. He received 5, and thus was 1 credit short of graduation and was not allowed to graduate from law school at that time. He premised his lawsuit on estoppel, and he lost. Yes, the promise was made, but no, that person had no authority to give that type of promise. We will now move to intentional misrepresentation. Intentional misrepresentation is, as noted, is when, first of all, notice the difference. This, unlike educational malpractice, which is not intentional, it's accidental, it's negligent, and hopefully it never reaches the level of gross negligence to norms or standards. In this one, this is not a question of an accident. This is a question of intentional misrepresentation upon which students rely. I would add to that, upon which students, as adults, reasonably rely. And an example I will give that will highlight that is actually when I left the large Philadelphia law firm and opened my own practice, one of my first clients was seeking an annulment. I met with her and said, I don't think you're appropriate for an annulment. There's really no basis. You didn't marry your brother, he didn't have a prior wife, and so forth. All of the typical indicia of requirements for annulment. She said, but he told me he was an architect. He told me he owned that beautiful home. He told me he made X number of dollars. And then after I married him, after knowing him for 3 months, I mean, not all marriage will be unsuccessful after 3 months, but that is all she knew him. The bank foreclosed on the house. He never had the degree. He didn't make that income, etc. So she said he engaged in fraud. This is the part that's relevant to us. She was my client. This is what she wanted me to advocate. I said, we're going to court. I'll ask for an annulment. I can assure you, at that session, the court's going to say, amend the complaint and ask for a divorce, which is exactly what happened. But this is the reason. The court said, when someone commits fraud, your reliance on it has to be reasonable. You knew this man 3 months. You had a duty, and especially today we would, with Facebook, with every kind of mechanism available online, to chart one's background and look at a potential mate with a higher degree of scrutiny than they could in colonial America. The court felt the reliance was not reasonable. Well, that comes into play in this as well. So it's not just the fraud that's committed by the institution, but the reliance that the student places on it must be reasonable. The cases that I'll give you include two, Alcides versus Brown Institute and another Bird versus Lamar. In the first, the students were promised certain elements to a computer course they were taking. Now, I do want to clarify, it's not promises, oh, this is a great professor, Tom Graves is terrific, which he is, but just assume he were not. It's not that kind of promise. It's the type of promise, not about, is it a great class and do you learn a lot, but very specific, concrete terms. So in this, the promises were made about what type of equipment was used in the course. In other words, how technologically advanced was it, the depth of the computer instruction, and the hours of instruction offered. These were specific promises that the court said it could examine. And since these were not forthcoming, that was an actionable cause of action, intentional misrepresentation. Another case, Bird versus Lamar, a 2002 case, is a case wherein the student sought to be a music media major. Such a major, I'm not intimately familiar with this major, but I can envision that this means sophisticated equipment. If you've ever seen the video that Freddie Mercury and Queen made, A Miracle, you see them enter this cavernous room strewn with, looks like moth-ridden instruments, spiders everywhere, spider webs. That pretty much equates the description of some of the rooms in which this education was given. So this student was assured repeatedly by officials that he was going to have this up-to-date equipment, software, musical equipment, and so forth. It never was forthcoming, and those promises were tendered every semester in college bulletins and orally by individuals such as the academic vice president. Ultimately then, and I should add, this student went to class and the professors often were not skilled in this arena and said, oh, just show up, you'll get an A. This is the type of a situation he confronted. So in this particular case, the student was successful against, let's put it this way, the court ruled that any faculty advisor, administrative advisor, who so gave fraudulent misrepresentations was subject to a lawsuit. But the college itself was not. And that's because, and it will lead to our next topic, this college, Alabama State University, was afforded immunity by its state constitution from a lawsuit. And that means it's rendered, you're incapable of suing them. I'll briefly describe sovereign immunity. Sovereign immunity really emanates from the king. No one could sue the king of England, or live to tell about it, I'm sure, because it was always correct. When we discarded the monarchy, we brought with us that notion of sovereign immunity. And now it's not the king who can't be sued, but the federal government who cannot be sued. And indeed, you cannot sue our federal government unless it has conveyed permission via statute. For example, such as the 1946 Federal Tort Claim Act. That immunity was also extended to the states. as part of the United States federalism scheme via the 11th Amendment. Because after all, these colonies, these states had been individual entities. And so the federal government was affording recognition to these states. This issue, of course, is in the news all the time. Does Arizona, is it not empowered to enact legislation to address problems of illegal immigration? Or does this only belong to the federal sovereign? Is that only their preeminent arena? So we see these issues many times. I would add that via the 14th Amendment, Congress has provided that even if you're a public institution, these lawsuits premised on due process and equal protection can be brought. So this exemption is afforded in many instances via the federal constitution versus the state constitution. In some cases in California, if a community college is considered a state entity, it also can obtain that immunity. Lastly, I'd like to address this final topic of illegal or unlawful steering. I have no case law to tell you about with respect to this. This is a very new issue, which Tom Greitz brought to my attention via an article which is listed in your materials in the Chronicle of Higher Education. And the article is from October 11th, 2011. Briefly, illegal steering is something that has been in the legal lexicon since the era of civil rights. But generally, we're referring to illegally steering in the housing context. Illegally steering a Caucasian family away from a minority neighborhood and vice versa. This is the first time, to my knowledge, that this notion has been applied to faculty, academic advising. In this particular, and it is only at the stage of investigation. The Department of Education in Washington, Office of Civil Rights, is presently investigating this issue at Columbia University. Briefly, what happened? A Jewish student visited her advisor at Barnard and was interested in taking a course at Columbia. The advisor, with all the best of motives, nothing in what has been written in the Chronicle indicates or suggests that anything other than looking at the best interests of the student was at issue. Advised her to avoid a particular course in Columbia because the professor had a reputation for being anti-Israeli in posture. The student said, I think I can deal with that. I think I would be fine with that. But this advisor said, I think you would be better off with, and so she did. She, in fact, took another course. That is what has led to this investigation. And many scholars and officials, government officials who formerly held positions in education, higher education, have said they've never heard of this. It is very rare. Highly unusual, said Sheldon Steinbach, who used to be the higher education lawyer for the American Council on Education. And Charlie Nutt, the executive director of NACADA, is quoted as saying, this demonstrates clearly why all academic advisors must be given comprehensive and ongoing professional development, and not just about institutional policies and procedures, but also about ethical and legal issues. Finally, I would conclude, my recommendations are set forth, I believe, on some of the materials, but very briefly, given the posture that we absolutely want to do what's correct for our students, given the case law which illustrates that barring fraudulent misrepresentation, gross negligence, faculty and in his or her universities will not be held liable. Nonetheless, these lawsuits do exist. And the potential for further litigation clearly exists on the horizon. So my suggestions include the following. 1, clearly use language such as we use at Richard Stockton College, and I've looked at various bulletins from colleges, and I know you all do not, which says that the ultimate responsibility for all course selection lies with the student. Make that very clear, and make sure it is not inconsistently represented elsewhere, and make sure that no one orally contradicts that tradition. Secondly, clarify. You've seen cases where the bulletins were inconsistent. Make sure all inconsistencies are eliminated. Thirdly, when you meet with students, document all waivers, all changes, all alterations. When I meet with an advisee, I note what I've told that person so that are there any repercussions later, I have my notation. And I also note when the student never visits. So that it cannot, no statement can be made, I have routinely visited this preceptor, for eons. And finally, that everyone involved in advising be formally trained, perhaps annual sessions. Some commentators suggest this should be taught by the business lawyers in the business department. I don't necessarily concur with that. Anyone who reads this material, understands it, is absolutely capable of conveying this to their peers, but doing so will make people sensitive to issues of licensure, graduation, and graduate school mandates. And finally, in so doing, we'll all be exhibiting our bona fide attempt to do what is in the best interest of the students while simultaneously endeavoring to minimize any legal liability.
Thank you very much, Audrey.
You're welcome.
Unfortunately, I haven't seen any questions come up on the screen.
It's probably because I talk so much.
but it's packed with information. I think we all need time to digest it a little bit. But certainly you have both of our email addresses on the information that was mailed to you prior to the webinar. And Audrey in particular, but either of us will certainly attempt to answer any questions that you have if you want to send them to us by email.